Good afternoon, everyone. My name is Halley Auger. I'm an associate in the Alberta office of Samfiru Tumarkin. I'm here today to answer any of your employment law questions. As usual, we're going to get started with a little hot topic before the questions roll in. And I hope I'm not beating a dead horse here, but I want to stress the importance of having an employment lawyer review your employment contract. I know when you get a job, the most exciting thing is a new opportunity, new co-workers, an opportunity to, spread your wings and fly. And everyone is really focused on compensation. How many weeks of vacation am I going to get? What are my fringe benefits? Unfortunately, lawyers are eternal pessimists. And what we do is counteract the optimist in you that's hoping everything goes great with your new employer. The lawyers are there to really protect you in case things sometimes have to go their separate ways. And that can happen in a variety of different ways. Certainly it can happen if there's a termination without cause. You just get laid off, the company's not doing well. But there's also other circumstances that may be addressed in your employment agreement, like the ability of your employer to demote you and cut your pay. Normally, you would think that they're not allowed to do those types of things, but you may be accidentally agreeing that they can do those things in your employment agreement. And, in sort of all the excitement of the new opportunity, you may be missing out on the fact that you've agreed to let them demote you, let them cut your pay. And so there's a couple of things that we can do as lawyers from the outset to protect your rights. The thing about contracts is they are usually promises between people, and courts are there to uphold and enforce contracts, and so we need to make sure that you are protected sort of from the outset of your employment. There's a lot we can do as lawyers, but we can't wave a magic wand and go back in time and undo contractual terms. Now, that's not to say that you're hooped if you have an employment agreement. I also don't suggest that you simply just look at it and say, oh, well, it says my employer is allowed to do certain things, including demote me or cut my pay, terminate me and not provide me with anything more than the bare minimum. You should always have it reviewed by a lawyer because there's very particular and specific language that an employer needs to use to take away rights. And so just because you may think that the contract is allowing your employer to do something, you should get it double checked. So not all hope is lost. If you have signed an employment agreement, please don't hesitate to reach out. You know where to find us, employmentlawyer.ca. All right, let's turn to some of the questions we have. Question on YouTube from FNC 9899. My employer has recently announced that they will be implementing a fine system for incomplete tasks and infractions. If you're caught not in dress code or you didn't complete a certain task, you are required to pay money, which will apparently go into a fund to fund team events. Is this legal? I don't think so. I think this isn't really I don't think they can legally do it. I think if you said, I'm not participating, they can't punish you for it. They can't force you to do it. This almost seems like a voluntary accountability system. By no means do I think an employer can monetarily fine you for not doing tasks or having a shirt untucked or, not missing a name tag badge. So I don't think that's legally enforceable. No, I mean, governments can fine people. Employers can't fine people. I think your employer's trying to be a little cute and trying to enforce compliance, but the legal ways that an employer does that is discipline, and discipline isn't making you pay a fine. If someone's not following the dress code or not completing their duties, the employer has to engage in progressive discipline. They have to warn the employee of the infraction, tell them what standards do need to be met, and then ensure compliance by progressively disciplining you. If the employee then doesn't have their shirt tucked in, then they may lose a shift. They may have a written warning, a verbal warning, a progressive discipline policy that says 3 strikes, you're out, kind of thing. But no, the fine is not okay. Certainly if the staff members want to agree, and if it's a small fine, if it's a toonie jar or a loony jar and it goes into a jar that pays for the pizza party, that's not legal, I suppose, but it would be by consent, voluntarily. Your employer can do it, but I don't think they can force you to play their game. Okay, question on YouTube from Prof Squirrel. If your employer gives you 3 weeks vacation but calculates your payout at 4%, which equals 2 weeks, should the entire amount be paid out completely if it's unused, or only 2 weeks? All right, so just to clarify what Prof Squirrel is saying, for those who don't know, vacation pay and vacation time are calculated as a percentage of your wages, your salary. So if somebody is entitled to 2 weeks vacation, that's 4% vacation pay. So your employer can either bank your vacation time, and then it usually shows up somewhere, either on your pay stub or in your human resources people management system, or they can actually pay out your vacation pay. So what that means is when you go to take a vacation, one of two things happen. Either you get your normal paycheck in the situation where your vacation time has been banked, and then so you get your regular paycheck even though you're in Portugal or Spain. Or if you've been paid out your vacation pay on every paycheck, it means that every pay you're getting a little extra percent, but then when you take vacation, you're not getting a paycheck because you've already been paid. So employers can do it either way. So 2 weeks is 4%, 3 weeks is 6%. Under the Employment Standards Code, you're entitled to a minimum of 2 weeks vacation or 4% vacation pay if you've been employed for less than 5 years. If it's over 5 years, the mandatory minimum is 3 weeks. So I'm not sure this is what happened to Professional Squirrel, but it sounds like potentially the employee may have less than 5 years of service, but the employer has offered in an employment arrangement, employment offer, agreement, written or not, to have 3 weeks vacation, which is 6% pay. Under the vacation bank, if somebody doesn't end up taking their vacation, the employer has to pay it out, usually at the end of the year. Now, employers most often encourage employees to take it. Certainly, it's good for mental health. The other thing is employers don't want to have to pay it out, sort of in addition to the wages they've already paid. And so they're really encouraging you to take it. Now, use it or lose it policies are not legal. So your employer can say you need to take your vacation. Hey, it's December, you haven't taken your vacation, therefore we're forcing you to take your vacation. They can do that, but they can't say, well, if you didn't take your vacation, it doesn't roll over, you lose it. That can't happen. So for Prof Squirrel, I'm not sure what your employer is doing. If they say that you are entitled to 3 weeks vacation, you're entitled to either 3 weeks time off or 6% pay. So I don't know why your employer is only paying you out at 4%. If you haven't used all of your vacation, and your employer didn't force you to take it, at the end of the year, they should be paying out the bank, or they can agree to let you roll it over. So in 2024, you only took 2 of your 3 weeks, they can either pay it out at the end of the year or allow it to roll over. Certainly up to them. They can't have a use it or lose it policy. Okay, message from L on Facebook. My employer reduced my commission structure. I work in sales and has given me 10 months notice, during which my pay remains unchanged from the period before the decrease. I've been with the company for 18 years. Once the 10-month notice period ends, can they terminate my employment without providing severance pay? I live in Ontario. So this goes back to the topic that we were actually discussing a little bit earlier, and that's whether your employer is allowed to make negative changes, demotions, pay cuts. So for Elle, her employer wants to make essentially a pay cut. Normally, employers aren't allowed to significantly cut your pay. In Alberta, that usually means about 20%. I'm not sure if it's in Ontario, if it's 20% or 15%, but a 15 to 20% pay cut could be considered a constructive dismissal. However, what Elle's employer is doing is saying that change doesn't come into effect today. We're providing you notice that we're making this change. And so it's sort of this sneaky backdoor way of instituting either a demotion or a pay cut with notice. And so the question really is whether 10 months is reasonable. Elle says that she's been with her company for 18 years. We know she's in sales. Those are 2 important factors, but the other factors in order to assess a notice period would have to be age, availability of comparable employment. We'd also have to know a little bit more about your sales, whether it's what your level of compensation is and whether your industry is sort of niche or nuanced or if your skill set's transferable. But let's assume 10 months is decided to be a reasonable period of time. Then your employer really is allowed to do it. And what your employer is saying to you, you've got 10 months to decide if you're going to accept the demotion. And if you don't, then, go find a new job. We've given you notice, or you can decide you're going to accept it. Now, at the end of the 10 months, normally the notice will say something along the lines of, if you don't accept the change, then consider this your working notice that your employment is coming to an end. And of course, an employer can provide working notice. Now, Elle says she's in Ontario. I don't know if they're allowed to provide working notice for the severance piece in Ontario. In Alberta, they would be allowed to provide you with just working notice. So, Elle, I think you've got a couple of missing factors there that would be really important to the assessment. So I highly recommend that you reach out to one of our competent and capable lawyers in Ontario. We have offices in both Toronto and Ottawa, but we service all of Ontario. So please don't hesitate to reach out, employmentlawyer.ca. All right, question from Ali on Facebook. A couple of weeks ago, a woman I work with directly appears to have opened a spreadsheet I provided her, changed some values, and then showed my manager an error in front of me. I was able to prove that the error did not exist, but I'm 6 months pregnant and I don't feel comfortable being alone with her. What can I do to protect myself? Ali, it kind of sounds like you're having an interpersonal issue with one of your coworkers. I think it may be important to bring this to the attention of your manager or HR, just to sort of document what you're experiencing now. Certainly it could be innocuous, it could be a little issue, but if you're thinking, and I'm guessing that's why you're reaching out, is you're thinking that your coworker is doing this to damage your reputation, then definitely you're going to want to bring that to the attention of HR. The other things you may want to do, if you're not willing to bring it to HR because you're nervous about that, you can always do something to sort of contemporaneously document the situation. So I always recommend people send an email to themselves, because obviously emails have a timestamp. And so you can sort of report kind of like a diary, what happened. And that way, if anything further happens, you're creating a documentary record that's contemporaneous. You can remember all the factors. I think Allie's a little bit worried potentially because this worker may be out to get her. So certainly if that's the fear, it should be reported to HR. I don't know exactly about not feeling comfortable being alone with her. I'm not sure if that's it alone or there's more going on, but if there's more going on, certainly, and you believe it's a safety issue, the first thing you should do is bring it to your employer. After that point, there can be additional remedies. Allie, if there's anything further or more going on in your workplace that's causing you to feel this way, you may want to also have your case assessed by one of our lawyers. So please don't hesitate to reach out. Obviously, you can email us at help@employmentlawyer.ca, or you can use the contact us function on our website at employmentlawyer.ca. Okay. Okay. We've got a message on YouTube from Name Family. I got a layoff letter January 30th, and the company asked to stay until February 21st to take over that to others. I think what Name Family is saying is they've got a layoff letter on January 30th, and the company is asking them to stay until January 21st, until February 21st. So is it sort of an advance notice that a temporary layoff is coming? If I'm right in interpreting your question, then it sounds like your employer is letting you know that 3 weeks from now, you're going to be placed on a temporary layoff. Normally there's no common law right to lay off an employee. If you have an employment agreement that says they can lay you off, then that contract is potentially binding. Normally, your employer is not allowed to lay you off. You're allowed to treat those as a termination. You have been provided 1 week's notice, 3 weeks notice, and we'll have to consider how that affects any further entitlements. We get contacted by a lot of people who get temporary layoffs, particularly in Alberta. I don't know if it's other provinces. Alberta tends to be a boom and bust economy. We're also, we've got, a lot of the oil sands here. And so sometimes there are temporary layoffs that come, seasonally. So we are contacted by a lot of employees with temporary layoffs. More often than not, you can treat them as a constructive dismissal of employment. And so if you are interested in treating it as a constructive dismissal, if you don't want to go back to your employer or you think they're being funny about their temporary layoff, we've seen a couple of temporary layoffs where they've closed down the plant. They've laid off everybody. They call it a temporary layoff, but nobody's getting recalled. They're kind of just sort of being a little sneaky by calling it a temporary layoff because they're hoping that you go and get another job and so they don't have to pay you severance. If you think that's happening, or if you're concerned that you're not going to be recalled, if you've got any of those concerns, please don't hesitate to reach out. Employmentlawyer.ca is the best way to get a hold of us. You can also email us at help@employmentlawyer.ca, and your case can be assessed on an individual basis. Okay, a question from Gerald. Gerald says, I will be 64 this year and on disability for the past 3 years. What happens if the government changes retirement age to 67 and my policy says that they pay to 65 and I'm still disabled? Gerald, I'm not really sure if you're on long-term disability or if you're on CPP disability. Those are very different. In either case, you may be best reaching out to one of our disability lawyers or waiting for our disability law show. We have a couple of really fabulous disability lawyers. They're incredible. They know the ins and outs of disability law in every province. So you can either go to disabilityrights.ca or you can go on our website and see when the next live stream is. In particular, I highly recommend Martin Wilms of our office. He's Fabulous. Okay. All right, we've got a message from High Yield Gardening. Can you provide more information regarding the illegality of use it or lose it vacation days? Our company let us bank them, but then tried to stop this. They reverted, and now we're banking again. Well, sounds like your company probably got some good legal advice, because use it or lose it policies are illegal. And maybe they tried to institute it, and then somebody sort of said, you're not allowed to do this, and then went back to rebanking. I hope you didn't lose any of those hours. I hope they didn't wipe your bank, realize their mistake, and then say, okay, we're going to let you start banking again, but you start over from zero. You shouldn't have that. So High Yield Gardening, to confirm again, there's mandatory minimum amounts of vacation that must be provided, either as vacation pay or vacation time. And so your employer has to provide that either as time off or as compensation. It's got monetary value. That's why it's at 4% for 2 weeks, 6% for 3 weeks, 8% for 4 weeks. It actually has a percentage of your wages. So it's got monetary value. It's the amount of money that you would earn if you have your week in Portugal or Spain or Disneyland. So it's part of your compensation package. Now, those are just the minimum amounts, and your employer might provide you with more. So your employer cannot have a use it or lose it policy. If they let you bank them, what I'm assuming is that you aren't getting paid vacation pay on every paycheck. What you're getting is a little vacation bank that says, the hours or the days that you have. Your employer has to let you at some point take those hours off. Now, you work with your employer on the days or the weeks you're going to take off. But if you're not taking them and your employer says you have to take them, we're not going to pay it out, then the employer can impose the dates on you. But, they can't just sort of wipe your vacation bank, then tell you, no, it's lost, but then we, probably got some legal advice that we couldn't use it or lose it, and now we're just restarting your banks. Again, no, that's not a problem. Name Family has come back. He said that he worked there from 2021 April to 2025 February. So that's just shy of 4 years, and you've received 3 weeks notice of a temporary layoff. Name Family is asking if he can ask for severance pay, and the answer is maybe. Maybe you can, and maybe that severance is going to be more than the 3 weeks pay. Again, I'm highly encouraging you to reach out to our firm. There's definitely a few factors there that would suggest that you might be entitled to assert constructive dismissal if you're no longer interested in working with your employer and seek some severance. All right. I should know, when there's temporary layoffs and somebody wants to assert constructive dismissal, essentially they're saying to their employer, I don't consent to the temporary layoff, either, revoke it, or if you've already started the temporary layoff, say, I don't consent, please return me to work. If you don't return me to work, I'm considering myself constructively dismissed. So there's a couple of nuanced things that we need you to do. And it's always best to get a lawyer involved earlier in the process. We can sort of help get things going in the right trajectory versus sort of trying to recover things afterwards. Okay, so please contact us sooner rather than later. Deb McKay says, I was fired because my father died and I took 2 days off. Well, if you're from Alberta, we definitely have protected bereavement leave. You're entitled to take some time off in the event of an immediate family member's death. And if you were fired for that reason, certainly that would be illegal, because bereavement leave is job protected leave. I don't know Deb's length of service, but some employers will say, well, you're in your probationary period, you've missed 2 days, and we're just going to let you go and not pay you any notice or give you any notice or pay in lieu of notice. But when it's job protected leave, if you're off on bereavement leave, that's a little different. They can't terminate you in your probationary period just for any reason. It's still on job protected leave. Deb, if you haven't already, contact our firm. Certainly we can assess the facts of your case and see if you're entitled to some severance. Okay. Laura from YouTube. My niece works for a US company and she's very worried about her position. She lives in Canada. What rights does she have if they let her go because of the politics down there? Well, we are seeing this, and we're certainly expecting we're going to see it a lot more. Obviously, the political climate is causing a lot of uncertainty, and the uncertainty is for our Canadian employees and their employers. Frankly, the employers are greatly concerned as well. If your niece is worried that she's going to lose her job because of politics, whether it's just the politics themselves or whether it's connected to the tariffs, your niece can be let go, but it would be a termination without cause and she would be entitled to severance. And that severance actually can be a lot. It could be up to 24 months, depending on various factors. So if she's let go and she isn't provided with a reasonable separation package or a severance, then she should be contacting our firm to get her case assessed. So certainly she can visit our pocketemploymentlawyer.ca to do a little assessment online, which can then be, afterwards, you can have your case individually assessed by one of the lawyers at our firm. We'd really be happy to help you. We're seeing it a lot. We've got a lot of compassion for employees who are really worried right now about losing their jobs as a result of the political climate. It can be really scary. Often people are best off contacting us if they've been terminated, and then we're just assessing your severance package. But if you're really, really worried, you're not sure what's going to be happening in the future, and you sort of want to prepare and brace yourself, don't, just be up all night thinking about it and worried about it. When you want to know what you could expect if you are terminated, contact us. You're going to be doing, some Google searches, I'm sure, online. But, if you really want to get some specific, crisp legal advice for your individual situation, that's really going to give you that peace of mind, we'd be pleased to help you. All right. Well, I think that brings us to the end of today. I really appreciate everybody who came out today. We have, of course, a lot of live streams coming up. We're back in full swing after the holidays. So we've got Samfiru coming up tomorrow. And Lior's pretty much gospel. I mean, anything, he can say, you can take that to the bank. So feel free to follow up if we didn't get to your question today. You can always join us tomorrow with Lior. If not, I'll be back in probably a month or so. I've got a few of these booked and I'm always happy to give you some Alberta specific information. But thanks everyone. Take care.